Okay, good morning, folks. My name is Mike Wallerstein, and I'm the Commission Appointed Hearings Officer for this hearing on docket number 2016-0224, Peter and Ann Bosted versus Hawaiian Electric Incorporated. Today is Thursday, April 13th, 2023. Time is now 9:05 a.m. This proceeding is being held remotely via WebEx and the recording will be later posted to YouTube. This hearing is also being transcribed by a court reporter. The parties to this proceeding are Peter and Ann Bosted, the complainants, Hawaiian Electric Company Incorporated, the respondent, the Division of Consumer Advocacy, or the Consumer Advocate, and a series of LLCs, starting with Kona 50-18 LLC, numbered sequentially on up through looks like through 31. So all inclusive through 31, then skipping 32, then 33, 34, and 35. Also South Point Fit LLC, Hawaii Fit 12 LLC, and together all of those parties are known as the interveners or the solar parties. And if I have inadvertently missed one of those LLCs, I hope you'll please correct me, but now I will take appearances from the parties. In the order I call you, please state your name and who you represent. So first, is there an authorized representative for the complainants, Peter and Ann Bosted? Oh, perhaps they're in the lobby. They are in the lobby. Let me let them in.
Okay, that makes sense.
Peter, they're putting everyone up.
Good morning. Can you hear me, Mr. and Ms. Bosted?
Yes. Yeah.
Okay, very well. We've just gotten started, and I've announced who the parties to the proceeding are, and I'm now taking appearances on behalf of the parties. So would you please state your name and how you represent the complainants?
Well, my name's Annie Bosted. I'm one of the complainants.
Introduce yourself.
I'm Peter Bosted. I'm one of the complainants.
Thank you. Is there an authorized representative for Hawaiian Electric, the respondent?
Brian?
Hawaiian Electric?
Brian Hiane is there.
Thank you.
He may be having
Audio issues.
Okay.
Yeah, sorry, that was me, Joe Stewart, intervener counsel speaking, but I can see Brian Hiane here, who is counsel for Hawaiian Electric, so he may just be having issues hearing.
Okay, I see him as well. I see he's muting and unmuting. Mr. Hiane, we can't hear you at the moment, but Mr. Stewart has kindly introduced you. Maybe I'll come back to see if you can resolve your audio issues in the meantime. Next, I'll ask, is there an authorized representative from the Consumer Advocate?
Hi, good morning. First off, can you hear me? I know last time I was having issues with my mic.
Loud and clear.
Thank you. Good morning, Scott Boone on behalf of the Division of Consumer Advocacy.
Thank you, Mr. Boone. And is there an authorized representative from the interveners?
Hi, good morning, Mr. Hearing Officer Joseph Stewart, S-T-E-W-A-R-T, along with co-counsel Bruce Nakamura, and our co-counsel Bruce Voss is also on a separate feed.
Thank you. And we'll try one more time for Mr. Hiane. Can you hear us, Mr. Hiane? Maybe you can wave to let me know you can hear us.
Explanation.
I think he's trying to type.
Yeah,
Okay.
Getting
looks like.
ask if he wants to check it first.
No, I don't.
Okay.
I'll do it if it comes up.
Let me try one more thing here.
You saw that side.
This is
Hi,
unfortunate.
good morning.
Ah,
Good
is
morning.
that you, Mr. Hyuna?
Hi. Yes, I'm sorry. I had
No
an
worries.
audio problem. Yeah. Okay, can everyone hear me now?
Yes, can hear you now. Can you
Okay,
hear us
great.
now? Very, very well. Would you please, just for the record, state your name and who you represent in this proceeding?
You're on mute, Brian.
You're on mute.
I'm sorry. Brian Hyuna.
We got your first name, but not your last name. Still not getting anything. We had you for just a moment.
Brian Hyuna. Can you hear me now?
Yes.
Okay, I'm sorry. Brian Hyuna on behalf of respondents, Hawaiian Electric Company.
Okay. Thank you, everyone, for bearing with our technical difficulties. I appreciate all of the patience you have shown. And now what I'd like to do this morning first is address the pending motion for a continuance. So 3 days ago, on April 10th, the complainant's attorneys withdrew their representation from the complainant, citing irreconcilable differences. And on that same day, the complainants filed a motion to continue today's evidentiary hearing. So first, I'll ask the complainants if you'd like to be heard on that motion.
Thank you very much. Yeah, I think it's self-explanatory. We don't have counsel. We wanted counsel because they will give a professional feel to the hearing. And we feel that if we were to do it pro se, we would be in a learning situation, and we would probably hold things up. We would probably cause unnecessary delays. We would likely mess things up a bit. And we know that that's not in the interests of all the people coming to this table. So we decided to hire counsel. We were advised to do that, and we can see why. So I know the counsel for the interveners wanted to know why it took us so long to hire counsel when we've been in the situation for 6 years. So we wrote a bit of an explanation, which I hope you will consider. Okay, so it all started with December 19, 2022, when we wrote to the commission and asked for a hearing. However, at that time, we had no idea if it would be granted, and if it was, when it would be held. So we asked for it, but we didn't know whether it was going to happen today, tomorrow, next week, next month, next year. At the same time, we knew we'd be a lot better off with counsel. We are pro se, we can file briefs, but a hearing is in the moment. We do not have the skills or experience to do this effectively. We cannot get a second chance. Another reason, of course, was the cost. We planned to wait till after the holidays and then ask the community for financial contributions. That was our plan. Then the interveners responded on December 21st, and we responded again on December 23. So now we're right up to the holidays. We wanted the community to give us funds. We had fought for 6 years per se, meeting our own expenses. We knew an attorney would be expensive, and we would need the community's help. We deemed it best to hold a community meeting to ask for funds to help us hire attorneys. Once the holidays were over, we considered dates for the meeting. We wanted a Saturday afternoon, but in January, all Saturday afternoons are football. So our plan was to wait for Saturday football to be over and then hold a meeting. We had no idea what kind of lead time we had. The hearing would be in a month or 6 months or more or never. We had no time frame for this. However, on February 2nd, we heard from the PUC, thank you very much. We heard that the hearing was scheduled for March 9. At that time, it was a scant 5 weeks away. So now we had 5 weeks to raise funds, hire an attorney, and prepare our case. The very next day, February 3, we sent out invitations to all the people that had shown opposition to the Ocean View project in the past by writing letters to the PC transmission line. We chose February 11 as that was the first Saturday without football. The Super Bowl was the next day, a Sunday. Unfortunately, Saturday 11th was also the day on which we had scheduled Peter's birthday party, and his sister from LA had plans to fly in for it, and we had already invited many personal friends. Both events were equally important. We had the meeting from 3:30 to 4:30, and the birthday party started at 6. That shows the kind of urgency we attached to having a meeting as soon as possible. That's when we had the hour-long meeting at our home. About 30 people attended. We explained the situation and asked if people would pledge a donation. The results were encouraging. And so we went ahead and began the process of engaging Mr. Hurley and Dr. Isaki. The contracts were verbally agreed to on February 17. February 17 was when Mr. Hurley wrote to the commission saying that he and Ms. Isaki would represent us. This was a scant 3 weeks before the scheduled evidentiary hearing on March 9. Council deemed more time would be needed, and on February 17, they filed a motion to continue the hearing. On March 7, the order granted the continuance to April 13, today, an enlargement of time of 5 weeks. I don't think we wasted time between being granted a hearing on February 2nd and hiring counsel on February 17. Most of it was time between calling a community meeting and holding it. One must give people a reasonable amount of time or notice, or they won't come. In this case, we gave them a week. That was not enough for many. We got emails from a number of community members saying that they already had plans. In spite of this, the meeting was a success, and we were able to raise funds and engage a council.
Is there anything in addition you'd wish to say at this moment, Ms. Bosted? I may have questions after I've allowed everyone to address the motion, but I want to make sure you've completed what you've had to say.
What about the other things?
Do you need an explanation as to why our attorneys withdrew from the case? We don't really want to get into this at this point.
If you don't, that's okay. I don't need the
okay.
explanation.
Okay.
What this
Yeah,
is
I'd
simply
rather
an
not go
opportunity.
there if we can help it, but if
Okay, he said no.
okay, let's
Yeah,
leave it.
this is simply your opportunity to speak on the motion. I don't need any specifics that you don't want to give at the moment. So now, as I said, I'll allow everyone else a chance to address this motion. I'll start first with the interveners who filed a written response to the motion on April 11th, and I'll go to Hawaiian Electric, who joined the Solar Party's response, and then finally the consumer advocate. So would a representative for the Solar Parties like to address this motion?
Thank you, Mr. Hearing Officer. I don't want to regurgitate the entirety of what was in our filing, as I know you read that. The only point that I guess I'd like to address in regard to the issues that were put forth by complainant just now would be that at the moment that the intervener's motion to dismiss and then the subsequent motion for reconsideration was denied, it was known that there would be a hearing on this matter. That was in 2021. So complainants have had 2 years of knowing that there would be a hearing. Maybe they didn't know the exact date of the hearing, but they knew that a hearing was going to happen. That was certainly adequate time to engage counsel. And in fact, they waited till the last second to engage them on the first opportunity. Then for whatever reason, and obviously we don't know what reason, they came in and their existing counsel apparently was unable to serve or unwilling to serve, or they were unwilling to have them serve. It's unclear, obviously, from our perspective. But the bottom line is that, the 11th hour engagement already caused one continuance on this. This is their complaint. It's their obligation. It's their burden. So we think that it would only be fair after more than 6 years of this thing pending to go forward and let the the complainants represent themselves as they've done ably throughout the vast majority of the duration of this docket.
Thank you, Mr. Stewart. Next, would Hawaiian Electric like to take the opportunity to address the motion?
Yes, we would just echo the interveners' counsel's comments, and just to add, we hear and we understand the complainant's explanation. However, we submit that it still does not constitute good cause to continue the hearing further. As counsel mentioned, it's already been continued once, for complainants to seek counsel. So we submit that there still is not good cause to postpone the hearing further.
Thank you, Mr. Hiane. And now would the consumer advocate like to speak on the motion?
We're taking no position on the motion. Thank you.
Okay. So I have questions, I think, for both the movants and for the respondents and the interveners, but I'm going to start with my questions for the movants. So first of all, could you tell me what efforts you have made since the withdrawal of your former counsel, Mr. Hurley and Dr. Isaki? What efforts have you made to retain new counsel since then?
Well, I think we've made every effort that we can. As I say, I didn't really want to get into an explanation of where the differences occurred, but we first started having differences on the Friday.
No, he wants to know what we've done since Monday.
Oh, since Monday.
Yes, to find new attorneys.
Oh, new attorneys. Oh, yeah, we've done a lot. I spent all of Tuesday working the phones and writing emails to everybody. I talked to a lot of attorneys on the Big Island, because I think part of the problem why it was difficult working with Mr. Hurley and Ms. Bianchi was because they were in Oahu, and we would really like to have somebody on the Big Island do this for us. And we've got a few leads. Nobody wants to commit straight away without knowing more about the case. And so we will certainly follow up on the leads we have. And, as I say, we do have money now. We have, contributors behind us. We do have the backing. We have the funds that we did not have 2-3 years ago. And, I think we're in a good position. I mean, okay, this has been a major setback for us. It's not something we would have chosen. We consider it kind of back to square one. And, 3-4 weeks ago when we engaged our counsel, we thought, wow, this is great. We're going to have somebody to talk for us. We don't have to worry anymore. Everything's fine. And unfortunately, that turned out to be not to be the case. So I think that's enough. I could go on and on.
No, that's fine. I have a few more questions, although you've already
keep asking questions, because that way I can fill in the gaps in your concerns.
Okay, and you've already
to summarize. We do have some very likely prospects already.
Okay.
At this early date.
And just for the record, I want to be clear. That was Peter Bosted.
Yes.
Speaking. Okay, thank you. So from what you said, it sounds like you have good reason to believe that you will be able to retain new counsel in the 5 weeks that you've requested in your motion. Is that accurate?
I would say so. Nothing's certain in this world, and I can't be positive. I mean, I really can't.
Good reason.
But I do have every hope that we will somehow, one way or another, get somebody to represent us.
Okay. And my next question, and I'll preface this, please, again, you don't need to go into any details that you don't want to go into, but I will ask that if you believe you are able to retain new counsel, do you have good reason to believe that you won't ultimately come to the same irreconcilable differences that that caused the withdrawal of this first counsel with these new counsel?
Okay, again, yes. Nothing's certain, but I could say 99% sure that this will not happen again. The reason is that we've learned a lot. We've covered a lot of ground. I think the next person could be a lot easier coming in, but maybe not. I don't know. And I just think, although we're in a worse situation because we don't have counsel, I think on the other hand, the 5 weeks we have done a lot of the work that we need to do. And the problem is, of course, getting the counsel up to speed. This is a very complicated case with lots of moving parts. As you saw by the volume of exhibits that the other two sides submitted, there's a lot of information. And if we cannot expect our new counsel to read through all of that, so we have to point them to relevant things and get them up to speed. And that part, that's the hard part. And but I think if we engage a council that is smart and quick on the uptake, I think we can get there in 5 weeks. That's a lot of ifs, I know, but we're certainly going to bend over backwards and put this as top priority to get somebody and get them up to speed and meet this deadline. I really feel bad to keep asking for extensions. It's not something I like doing personally, and if it could have been avoided, I think we would have.
Okay, and my final question is, if I grant your motion, and despite your good reasons, you're either unable to retain counsel to represent you at the hearing, or you are, but they, again, withdraw or are unable to appear that day, will you be able to proceed with this complaint pro se, representing yourselves?
I guess we'll just have to, won't we? Yeah,
Yeah.
as I say, it won't be perfect. You're
Just
going
say
to,
yes.
yes.
Okay, thank you. And now questions for both Hawaiian Electric and for the interveners. Would postponing this hearing for approximately a month and a half prejudice you in any way? And I'll start with the respondent, Hawaiian Electric.
Well, we'll have to see on my witnesses' availability. I think that would be the biggest issue we would have. Our witnesses set aside time today, to be prepared to go forward. And so I'll have to check with their scheduling. But I think that would be the biggest issue that we would have.
Okay, thank you, Mr. Hiane. And for the interveners.
Thank you, Mr. Hearing Officer. Apart from, witness schedules and obviously, everybody prepping to get ready for today, the one other aspect I guess I'd like to raise is that, our clients have made substantial investments into these properties. Every day costs money, and, every day that the projects aren't started, supply chains and everything are getting worse and worse and worse, and costs go up, and some certainty, I think, especially after 6 years, is reasonable to expect and to hope for. So I think there are economic damages that occur, and that's why, again, we didn't particularly oppose the initial continuance, but why we're saying that I think one is enough. So that would be our position on that.
Thank you. And just to confirm with the consumer advocate, since you took no position on the motion, I would otherwise offer you an opportunity to speak, but since you have not taken a position, I'm assuming you have no interest in speaking on the motion.
Thank you. Yes, that is correct.
Very well. In that case, I'm prepared to rule on the motion. I'll do so orally, but I will also provide a report in the docket so everyone can read it. So this is not the first time the complainants have requested to postpone the evidentiary hearing specifically for matters relating to their representation. They first requested to postpone the hearing on February 17th, and I granted this request so that the complainants' newly retained counsel could familiarize themselves with the case. In granting that motion, I said, allowing the complainant's new attorney sufficient time to prepare for the hearing will promote an efficient hearing and the development of a sound record. Further, no party will be significantly prejudiced by a brief hearing delay. Today, I still believe that if the complainants are able to retain counsel, and that counsel actually represents the complainants at the hearing, that such representation would promote an efficient hearing and the development of a sound record. But I'm very concerned that the respondent and the interveners and the consumer advocate all expended resources to ready themselves for the hearing today, and that postponement at a minimum will be frustrating to them and costly to them. Moreover, based on brief representation from the complainant's former attorneys and their subsequent withdrawal for reasons that are not entirely clear, and with that withdrawal being so close to today's hearing date, I am very concerned that the complainants may have difficulty retaining representation in a timely way or getting their representatives up to speed in a timely way. And so I'm concerned that if I grant their requested continuance without any conditions, we might end up in this position again where all parties are ready to proceed except for the complainant. And I very much don't want to end up in that position. So ultimately, I do believe if the complainants can be represented by counsel rather than proceeding pro se, this will promote an efficient hearing. And that to me is the reason, in spite of the prejudice to the other parties in this case, that I will grant their motion, but it's going to come under 3 conditions. First, absent circumstances that are both extraordinary and unforeseeable, I will not entertain any future motions to continue the hearing. We will go ahead with the hearing on a newly scheduled date, whether or not the complainants have retained counsel. Second condition is, under no circumstances will I allow the complainants to expand the scope of this proceeding beyond the one remaining issue, which is count 5 in their complaint, whether the solar project owners improperly circumvented the competitive bidding process. Third condition is, under no circumstances will I allow the complainants to add any new witnesses or exhibits. With those 3 conditions, I will grant their motion for continuance, and now I would like to discuss possible dates for a new hearing. The first available date that I have would be May 30th, and I would propose the same time, 9 a.m. So I'd ask you all to please check your calendars if you can right now and see if you can tell me that date definitely won't work, or if you think it could. I'd like to know that now so we can simply set this and begin preparing for that date. So I'll ask first to the complainants, May 30th.
This is Annie Bosted. Mr. Hearing Officer, thank you very, very much for agreeing to our postponement. We really appreciate it. And we will try and, aside from the last,
Anyway, go ahead.
Yeah.
He's asking about the date.
the date will
May
not
30th.
work. No.
May 30th will not work.
I'm sorry, no.
Will
I
May
wish-
31st work for you?
No, we'll be gone till June 12th.
Till June 12th.
Back on the 6th. No, well, sorry,
It's June 12th, Don.
the river trip is over on the 6th.
Yes.
So oh, you can skip that.
Okay. Okay, we could change our plans and be back on island by
June 7th.
June 7th. But yeah, after a vacation, I always take a while to recover.
Okay, maybe June 8th, would that work?
June 8th, yeah, I guess it'll have to. It'll give us no time between our vacation and the hearing, but we're just so pleased that you're giving us this postponement that I don't think we're in a position to quibble. So we'll just have to make it work.
Let me confirm with the other folks that June 7th is available for them. I'll start with respondent Hawaiian Electric.
Excuse me, you just said June 8th, I believe.
I'm sorry, I did, June 8th.
Hearing officer, I am available. I am checking with my witnesses now on their
Okay.
availability.
Okay, I will, for the moment, assume that they will be available, but if they are not available, that limitation on motions for a continuance applies to the complainants. It does not apply to Hawaiian Electric at the moment. So if you need to move that for witness availability, that's I will entertain any such motion. Next to the solar interveners, June 8th, Thursday.
Same reservation as far as availability of our client. I am currently available. Mr. Nakamura is checking his calendar as well.
I have kids graduating, so.
Yeah, so graduation trips, obviously can't be moved. So if we perhaps could get back to everybody no later than tomorrow, then that would be best.
Okay. That's fine. And want to confirm for the consumer advocate, June 8th, is that a possibility for you?
June 8th works for the consumer advocate. My understanding, as a result of discussions in the first pre-hearing conference, is that no party would object to our executive director being excused from the hearing. So as long as that's still the case, June 8th works for us.
No objection from interveners.
No objection from respondents.
Any objection from the complainants?
No.
Okay, thank you. So here's what we'll do. Let us tentatively plan on June 8th as our new hearing date at 9 a.m., but I will wait to, as Mr. Stewart suggested, to the end of day tomorrow to hear confirmation or not that will work. And if it won't work, please send by email, send to me and all of the parties 2 proposed alternative dates. And I will wait to issue my order after this so that I can include the actual date, which I am planning for at the moment to be June 8th. But if it can't be June 8th, then I will put the actual date in that order that goes in the docket.
Okay, thank you, Mr. Hearings Officer.
I can't do it. I can't do June.
Thank you.
I won't be,
I'm sorry, Mr. Nakamura just confirmed that he will be on a plane on the 8th. So
Okay. What
So
is your
maybe-
earliest available date after June 8th?
Was June 7th unavailable? I mean, I understand it's tough to come back from vacation, but
June 7th would be great.
but if June 7th works for everybody, then that would work for us, subject to our client, obviously. We haven't talked to him yet, but
Can I answer?
Yeah, June 8 is really pushing it.
Let's, we will be on a river rafting trip until June 6th and flying back on June 7th.
okay,
So
okay.
it's not.
Understood.
Yeah, I mean, we've already booked this trip months and months ago.
13th. I'm coming back on the 13th, so later that next week.
So, okay, so we would be available
On
the
15th?
15th or after that, subject to specific availability. So if the hearings officer has a date, perhaps there, maybe we can all check now. Again, subject to client reservations that I know Brian and we both have.
So let's see. Friday, June 16th. How about that?
Fine, that's fine with us.
Okay. Hawaiian Electric.
June 16th is okay.
Yes, I am available. I'm checking with my client. And
Okay.
we will get back to you no later
Understood.
than tomorrow.
On behalf of interveners, both counsel are available, and we just need to check with our client, but we can confirm that tomorrow. by
Okay.
tomorrow.
Very well. And the consumer advocate, June 16th.
Same request for our executive director to be excused, but we are available on the 16th.
Okay, understood. Then let us tentatively plan for June 16th, 9 a.m. I will expect any notice that date is not doesn't work for any witnesses by the end of the day tomorrow. And if I haven't received that, then I will assume that is the date we're going to have this hearing, no matter what. Is there any
Thank
other
you, Mr. Hearings Officer.
Thank you,
Is there
Mr.
any-
Hearings Officer.
You're welcome. Is there any other business we need to cover before we adjourn for the day?
Yeah, I have some questions. Who exactly will the witnesses be? At the first hearing, it came up, would Mr. Kevin White be available? And I think Mr. Nakamura said that he thought so. And then also Mr. Hawaiian's witnesses, they originally there were 3, and then when they filed their testimony exhibits, I saw only 2, and now it seems like one of those people isn't going to be attending. So, Ms. Hawaiian, would you mind letting us know exactly who your witnesses will be? And perhaps Mr. Nakamura could tell us if Mr. White will in fact be attending.
Our witnesses, as we disclosed in the witness list, our witnesses are going to be Mr. Greg Shimokawa, and he will just be adopting Ms. Rosella Motoki's previous testimony because Ms. Motoki has retired. Also testifying will be Ms. Amanda Lee.
Amanda Lee, okay. And so Mr. gosh, I forget his name, gentleman from Helco, the engineer. He won't be testifying then, right? Dave Okamura, I think his name is.
Dave Okamura, no. We submitted his written testimony on the record, so he's not going to be testifying at the hearing.
He won't be testifying. Okay, thank you very much. I appreciate that.
And on behalf of interveners, Mr. White will be the only witness that we have.
Great. Thank you.
Can I ask my question? So another thing that's been very confusing to us is the witness testimony that has been submitted by these 3 witnesses in writing covers a lot of ground. And it's not clear to us that whether or not we're allowed to question every statement made by the witnesses, presumably because they submitted it for this particular hearing. So I was wondering if the hearing officer could clarify that any statement made by the witnesses is subject to our questioning cross-examination.
Yes, any statement that is made by a witness submitted as testimony that they swear to is subject and open to your cross-examination at the hearing.
Thank you.
Mr. Hearings Officer, may I raise a point?
Yes, please.
Okay. I guess the only caveat that I would offer to that or suggest to that would be that there is only one issue that is remaining, as you've noted. There is no ability to expand that issue. The testimony that was submitted both by the interveners and by Hawaiian Electric was submitted prior to those issues were narrowed down. We did not go back and redo the testimony because we had already submitted it. So there is a significant portion of it which relates to other issues which are not part of this particular hearing. So I guess I don't want it to be a surprise that if questions are asked outside the scope of things relevant to the one issue remaining, I certainly will be anticipating objecting. So just teeing that up so there's no surprise on that front.
I completely understand, and that is part of this hearing process, that there may be objections to questions, and one of the grounds for an objection could be whether the question is relevant to, or the testimony is relevant to the one issue in this case, and I will weigh that objection. Should it come, when it comes, I will weigh that and either determine that the question should be answered or not. But yes, I was anticipating that, and I hope now that the complainants are aware that there may be objections to any questions you or your counsel should ask, and I will rule on those objections if they come, when they come.
Thank you, Mr. Hearing Officer. Should I talk about the piece? Okay, we have one more thing that we would bring up. At the very first hearing, the first pre-hearing meeting, you asked the parties to seek a settlement. We are in favor of discussion rather than adversarial arguing. However, we have been warned that it's not a good idea to talk peace while the fighting continues, if you don't mind our colloquial English. Thus, we have not talked peace. As you can see, the other sides are pretty aggressive and critical of a lot of what we do and say. So since you are in favor of a settlement, would you consider talking to us, the complainants, and listen to our proposal, and then evaluate whether the commission would find it acceptable? We think that it provides an equitable solution and removes many of the objections and shortcomings of the Ocean View project as it's presently envisioned. I would emphasize the equitable part. I think our solution has something in it for everybody. And but again, we don't know that we're not experienced enough to be able to talk peace and argue without losing ground. And so we would like to talk to you away from the situation, one-on-one, face-to-face, or WebEx to WebEx, and just sound you out, if you like, and find out how you feel. Would you be open to that?
I understand your interest in that, but I am legally and ethically unable to do that. That would be an ex parte communication between me and you without the other folks present. That is simply not allowed. So I can't do that, and I won't do that. What I can do is encourage you to do a couple of things. One is you are free to make any settlement negotiation offers, overtures to any of the parties in this case without me present, just because I may not speak to any of you individually about this case, unless it is about the most basic procedural matters. I'm not allowed to do that. But you are free to speak with each other without me present, without any one, you could have a one-on-one meeting with any of the parties if you so choose. I understand why you might not be comfortable doing that, especially at the moment without an attorney representing you. If and when you get an attorney to represent you, that attorney might be much more comfortable engaging in settlement negotiations. Settlements are something that the Commission generally favors, not speaking about the particulars of this case, but just as a general matter, settlements make our lives easier. If the parties come to us with a proposed resolution, we are certainly open to that possibility. I am certainly open to that possibility up until the day of the hearing. So I would encourage you to, if you're not comfortable reaching out directly to any of the parties without being represented, I understand. When you get your attorney or attorneys, I would encourage you to discuss that settlement possibility with your representatives. The other alternative, if you'd like, is you could propose something in the docket. In other words, make a filing in the docket, much like the filing that you made to move for a continuance. And that way, the ex parte concerns are solved. I will not necessarily respond directly to that if that's the route you choose to go, but this would be a way for you to have everybody see what you're proposing. But unfortunately, for both legal and ethical reasons that are absolutely binding, I cannot have a one-on-one conversation with you about your proposed settlement.
Yeah, we understand that. We understand that. Thank you.
I think just to clarify, our settlement proposal would need to involve the PUC in the settlement negotiation. So we would need to have who would be the representative from the PUC that would be involved in the settlement?
That's a good question. I think potentially it would be Mr. Relf, who is on the WebEx with me today. He has been the one representing the Commission thus far in this matter. So that's my best guess, but it would be subject to confirmation from our Chief Counsel.
Thank you. That's good information.
All right. Are there any other questions or issues that we can resolve before adjourning today?
May I address the settlement mediation point very briefly?
Please.
Okay. I would like to just announce that on behalf of the interveners, we are always happy to discuss mediation. In fact, to that end, we filed a motion already many years back, 2017, seeking mediation, which unfortunately the complainants opposed, but it has not been ruled on by the Commission. But where we are now, of course, is that these suggestions keep getting raised at the 11th hour, and while we're happy to discuss settlement, we're not interested in any kind of continuance or postponement of this new hearing for a third time to do so. So it would need to be parallel tracks. So we would suggest strongly that to the extent that any party is interested in settling, that offers be initiated very quickly so that we can dual track this along with prepping for the hearing. Because unless there's, I never say never, but unless there's a real substantial traction towards settlement, we would not be in favor of any continuance for any kind of compelled mediation. We tried that already. It was refused, and that's not something we'd be interested in at this point in time. But we have 2 months now, and we're happy to discuss settlement at all times.
Thank you very much, Mr. Stewart. We agree that with everything you say. We are not asking for a continuance. In other words, we can do it in parallel. We don't have to negotiate and then fight. we can negotiate while we prepare our case. And especially since we've been given more time than we originally asked for, I don't think that's going to be an issue. It's more goodwill, I suppose. You know, saying, well, we've already proposed something and you turned it down, it's all your fault, is not a good start. What you did offer us was not very concrete, and we simply couldn't accept it. And I'd like for you to put that behind you and consider today to be the first day and move forward. And I think if we negotiate in good faith, I think we can find a solution that will suit you and suit us and Mr. Hawaiian and the commission. And I think if we can keep all four parties happy, and we will have done a lot more than simply going into arbitration, which we were not willing to do. Thank you.
So I do appreciate this overture about settlement. I think this could lead us in an unexpectedly good direction today. So I do encourage you to continue these settlement talks. If there's anything that I can do to help that along, please do let me know. I do want to say two other things on that. One is that settlement negotiations between the parties may remain completely confidential, including from me. I don't need to know what is discussed in there. You are free to take a position in settlement negotiations and then take a very different position at the hearing if those settlement negotiations don't produce a settlement. So don't worry about that if you were. And finally, I also am not interested in having settlement negotiations delay this hearing either. So to the extent that you can proceed in parallel, please do. But I'm not interested in another continuance. So I think that's all I have to say about settlements. Is there any other business we can attend to before we close off for the day?
Nothing from interveners.
And I would just like to ask that, I'm sorry.
Yes.
If I can, I'd just like to ask that the Division of Consumer Advocacy be included in those settlement discussions. I know I heard Ms. Bosted mention 4 parties. I'm not sure if you were contemplating us, but I would ask that we be included as the talks are going on so that we're not asked to look at something at the last minute. And I'll after this hearing, I'll provide you with my contact information.
Thank you very much, Mr. Boone. Yes, I do apologize for leaving you out. Yeah, of course, we would love to include you. In fact, if you would like to be the peace negotiator, we'd love to give you that job.
Very well. Well, then, without getting any farther down the road of substantive settlement discussions, I'd like to thank everyone for their time and attendance, and also for their forbearance with our various technical issues. I will, again, expect to hear from folks by the end of the day tomorrow if they expect any witnesses to be unavailable on Friday, June 16th. But if I don't hear that, then I will plan to go ahead with the hearing, evidentiary hearing, on Friday, June 16th at 9 a.m. on this same WebEx platform. I will put a notice in the docket next week that both confirms that date, provides a new hearing link, and also summarizes what was discussed today, including the conditions on the continuance that I granted. And I believe that is everything I needed to say. Thank you, everyone.
Thank you.
Mr. Hearings Officer.
Thank you.
Thank you.
Thank you.
Bye, everybody. Have a nice weekend.